Thanks for stopping by and checking out my videos. And if you want to learn more about my book, Love Like Snow in Florida on a Hot Summer's Day, go down to the description. I have the links to both my website and Amazon and Kindle Unlimited, where you can read it for free. Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here with another update. And so I told you guys that we could expect to start seeing motions being filed by the defense in response to the motions that we went over this weekend from the prosecution. And so I was trying to hold out to see if more information was going to come out or more filings, and then I could just do one video. But that doesn't seem to be the case. Maybe they are working diligently to respond to all that information that was put out that the prosecution wants to enter. All of these Jane Does they listing. I mean, it is just a mess. If you don't know what I'm talking about, then please go back and check my videos that I did this weekend. It is a 3-part series, and it is reading the motions in limine from the prosecution, about how they are going to address this trial. And they are very long, but it is worth the listen so you can get a clearer picture of what's going on with the case and how they are going to present it to the jury. So one of the things, I think it was part 1, was where the prosecution listed some of their expert witnesses. And so Nicole Becker has come out with a motion for someone that they are going to enter as a witness. And so it says, "Dear counsel, pursuant to Rule 16b1c of the Federal Rules of Criminal Procedure, the defense anticipates and hereby notifies you that it intends to call at trial in the above referenced matter Dr. Marcus Deveraux to testify about the matters described below. A curriculum vitae of the expert will be attached. The defense reserves the right to call substitute expert witnesses." And so Dr. Marcus Deveraux is a medical doctor who holds a federal DEA professional license. He is board certified in both pediatrics and child abuse. He has held his certification since 2003 and 2009. Dr. Deveraux currently serves on the board of directors at St. John Medical Group in Detroit, Michigan. He also is a member of the board of directors at Ascension St. John Foundation. Dr. Deveraux is also the director of business operations at St. John Hospital Pediatrics. He is the co-chair of St. John Providence Physician Network Governance Council, appointed by the hospital CEO. Dr. Deveraux is a member of the Wayne County, which includes Detroit, Michigan, Death Review Team. Dr. Deveraux also possesses several peer-reviewed publications, including but not limited to Deveraux M., Makarov K., Shapiro R., Examination Findings in Prepubertal and Adolescent Females Who Present Within Gonorrhea or C. Trachomatis, Vaginal Infections, PAS/AAP, Joint Meeting Publication, May 2003. He also has a number of clinical guidelines, for example, Deveraux M., Shapiro R., Chlamydia. Oh Lord, child, they just going on. So basically, I'm not reading all these publications that he has, but basically he is going to come in and talk about the herpes allegations and respond to those. And so basically she's saying that Dr. Deveraux will testify about how herpes simplex virus, HSV, is one of the most common sexually transmitted diseases in the United States. He will testify about whether HSV is asymptomatic or symptomatic. Dr. Deveraux will testify about testing after exposure to HSV and whether or not an individual is able to determine if the exposure and/or infection occurred during that exposure or possibly another exposure. He will explain the reasons that an individual was quite possibly already infected prior to exposure, whether or not serological testing for HSV assists or does not assist in determining when an individual was infected. Further, whether serological testing has any value in attempting to determine whom an individual was infected by, how the disease manifests and presents itself, and when attempting to determine who the individual contracted the disease from, the fact that the number of prior sexual partners plays a role. Dr. Deveraux may also explain certain medical records, including those belonging to Mr. Kelly and Jane Doe number 6. So that is one of the expert witnesses that the defense plans to call in. Then the second filing that came from the defense was from attorney Cannick, and he is basically going to address this request from the prosecutors that these women, don't have to be identified, okay, when they are testifying. And so the prosecution wants them to either go by their first name only or by a fake name. And so the defense is saying, no, it doesn't go that way. So Attorney Cannick writes to Judge Dunley and says the defense respectfully submits this letter, brief in opposition to the government's motion in limine, which requests that the court, 1, permit the victim witnesses to testify using a pseudonym or their first names only, 2, limit references to each of the victim witnesses in open court to their pseudonyms or first names only, and 3, prevent public disclosure via cross-examination or otherwise of the victim witnesses' respective addresses, names of family members, or exact place of employment, if any. Motion ECF doc number 121. For the reasons set forth more fully below, the defense consents to Jane Doe's number 2 and number 3 being referred to by their first name and strenuously objects to the government's application regarding Jane Doe number 5. So response to government's motion in limine, Jane Doe number 5 identity. The identity of Jane Doe number 5 is necessary for the in and out of court investigation. The Supreme Court has long recognized a defendant's right to confront government witnesses with questions regarding identifying information, such as their true names, addresses, and employers in Smith versus Illinois, which was a 1968 case. A prosecution witness testified under a false name, and the defense was prevented from eliciting the true name and address on cross-examination. The Supreme Court overturned the conviction on the ground that the name and address of a witness are necessary for a defendant's in and out of court investigation. In this case, the disclosure at a public trial of the identities of the witnesses against Mr. Kelly is essential for a thorough investigation of the witnesses. Accordingly, defense counsel should be permitted to inquire into the witnesses' true identities during the cross-examination. See Alford versus United States, which was a 1931 case. Cross-examination of a witness is a matter of right. Its permissible purposes, among others, are that the witness may be identified with his community so that independent testimony may be sought and offered of his reputation for veracity in his own neighborhood. The identity of Jane Doe number 5 is essential as it directly bears on the witness's credibility, bias, and prejudice. Additionally, the identifying information of Jane Doe number 5 must be presented to the jury as the evidence bears on the witness' credibility. In Alford, the Supreme Court reversed a defendant's conviction because, inter alia, the District Court impermissibly prevented defense counsel from obtaining the address of a prosecution witness. Information the Supreme Court held went directly to the witness's credibility, bias, and prejudice. As in Alford, in the instant matter, Jane Doe No. 5's identity goes to the heart of her credibility. Specifically, as the government mentioned in its motion, Jane Doe No. 5 has spoken publicly about some of her experiences with Mr. Kelly. Government motion ECF doc number 121, page 11. In fact, Jane Doe No. 5 has already revealed her identity to the public through press and by discussing her relationship with Mr. Kelly. The defense submits that Jane Doe No. 5 has conducted numerous interviews regarding Mr. Kelly and has participated in several documentaries which were made available for public distribution. For example, in late 2020, Jane Doe No. 5 conducted an interview for a Fox station in which she discussed Mr. Kelly. At the present time, there are 10 or more videos available on YouTube of Jane Doe No. 5 discussing Mr. Kelly. There are also several videos available on the internet of Jane Doe No. 5 appearing by herself or with her father in which Mr. Kelly is discussed. The parents of Jane Doe No. 5 have also conducted various media interviews, including an interview in 2019 with CBS This Morning. In addition, Jane Doe No. 5 has conducted several Instagram live sessions in which she discusses Mr. Kelly. Some of those Instagram live sessions have been recorded and appear on YouTube or are readily accessible on the internet. Therefore, the need to keep her identity anonymous has been directly undermined by her own actions. Further, the fact that Jane Doe No. 5 has spoken out publicly and, in fact, published a book about her experiences with Mr. Kelly bears directly on her credibility as a witness. Now, I wasn't aware Jane Doe No. 5 wrote a book. I think he might be confusing her with Jane Doe No. 4. If you guys know about a book that Ariel has written, please let me know where I can find it at. So, enabling defense counsel to elicit her identity and this information regarding her public announcements, which vary from her in court testimony, would provide information that is relevant to the jury's deliberations as to her credibility and is essential to the defense. Permitting victim witness to testify under pseudonyms impermissibly undermines the presumption of innocence. The government also seeks an order permitting the victim witnesses to testify under pseudonyms. However, if the government's witnesses are permitted to conceal their true names, then the court would be sending a clear message to the jury that this case requires special protective measures for government witnesses. The average juror who has seen any amount of television or movies or previously has been on a jury will know that it is unusual for a witness's identity to be concealed. The jury likely would infer that the court has implemented these extra precautions because the women testifying are uniquely vulnerable, the defendant is particularly dangerous, or both. In short, anonymous witnesses will interfere with the jury's ability to provide Mr. Kelly with his presumption of innocence during the course of his trial. In this regard, government's request for anonymous witness is comparable to a request for an anonymous jury. In such cases, because the Second Circuit has recognized that the use of any anonymous jury undermines the presumption of innocence, it has cautioned district courts that the decision to impanel an anonymous jury must receive close judicial scrutiny and be evaluated in the light of reason, principle, and common sense. United States versus Thomas, which is a Second Circuit decision from 1985, the same standard should be applied here, and accordingly, the court should deny the government's request for the witnesses' anonymity. I have trouble pronouncing that word. Therefore, based on the foregoing, the defense consents to Jane Doe's number 2 and number 3 being referred to by their first name and strongly objects to and opposes the government's application regarding Jane Doe number 5. So they seem to be okay with people not knowing who Jane Doe number 2 and Jane Doe number 3 is, which I find to be very, very interesting. And I totally wholeheartedly agree with Jane Doe number 5, because everybody knows who that child is. And so that is the first response that has came from Deveraux Cannick. So we will have to see if the prosecution comes back with an argument as to why they think that Jane Doe number 5 needs to be kept a secret. And I think, I go back to the part about the book. I think he may be confusing Ariel with Geronda. And did the Patrice Jones, who we believe is Jane Doe number 2, did she write a book? And then I still don't know who this number 3 is. So that is going to be very interesting to see who that is. And then on a side note, it seems to be going around that, for those of you who watched the videos over the weekend where they talked about the John Doe number 1 and John Doe number 2. So it is being put out there that John Doe number 1 is actually Richard Arline. And you guys know that Richard Arline is the one that was part of that whole scheme to allegedly bribe Ariel. And I have, said in my previous videos that I believe that that whole bribery scheme was set up by the Clarys, possibly Larry, and then the Richard Arline just played into that. And so now, speculation is that John Doe number 1 is actually Richard Arline. I did the math and the numbers add up, because supposedly whatever happened in 2006 and the person was 16. If you add on to that and get us to 2021, Richard Arline is 31 years old. And so, when you do the math, it could possibly be him. I don't know. I don't have any way of confirming that information, but the Twitter sphere seems to feel that he is the person. And that would just make it even more interesting, and then really get us to thinking about how far this whole setup is going, because now you got people that interacted with Richard Arline. Maybe this is something that Judge Dunley knew about, because remember, she told R. Kelly he needed to get Nicole off of his case. R. Kelly said he wanted to stick with Nicole, and she made it very clear to him that if some stuff come out during this trial involving Nicole, you're not going to be able to appeal it, because I'm giving you the opportunity now to get her off your team. But he said he wanted to stick with her, so he's sticking with her, okay? And Nicole was supposedly on the call with Richard Arline and Ariel and all these other people, Dr. Rice and all that. So this is going to be very interesting to see how this whole thing plays out. But I just wanted to bring you guys this information. Was hoping some more motions would have been filed by now, but they aren't. So I guess I'll continue to bring you these little short videos as this thing moves closer to court date, which is only weeks away. So guys, go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.